Carol Beaumont.
Thank you very much, Mr Chair. Well, let me start by taking up the challenge that various of my colleagues have given the House and saying that my first vehicle was a baby blue Mini with a fiberglass Clubman front. I know. I was quite young at the time, but a very cute little car, I have to say, and I thought it suited me very well. So I'm looking forward to hearing what the Honourable Minister's first car was as well when he gets up to speak. I acknowledged our new Minister in my previous contribution, but can I also acknowledge Heather Roy, and it's great to see her back here, so that's wonderful. Now, I want to talk specifically about provisions in the bill about the Disputes Tribunal, and actually my colleague Leanne Dalzell, the Honourable Leanne Dalzell, went through a bit of the background on the process, and while it's fair to say this has taken quite a long time, it's actually been a reasonably effective review process, and the matters that were raised have actually been dealt with in this bill, which I think is a very good thing for this House, that we have a robust process where we review things, we get people's input, we then translate that into a bill and it comes before the House, albeit perhaps somewhat slowly, except for the final bit which is being forced through under urgency, which does seem a little strange. But anyway, I want to talk specifically about the Motor Vehicle Disputes Tribunal, and there are changes in this bill around the jurisdiction of the tribunal and also around decisions being publicly available. Now, the Motor Vehicle Disputes Tribunal, established under the Act when it was brought into effect in December 2003, can hear claims under the Consumer Guarantees Act and the Fair Trading Act, Sale of Goods Act, and it basically it can only decide claims where one party is a motor vehicle trader and the other party is not. Currently, claims up to $50,000, and this bill amends that, increases the jurisdiction to $100,000. Now, I took the time to have a look at what was suggested in the part of the process where the discussion document went out after the review. The review actually had 12 recommendations, and there were 2 that I could see that related to the Disputes Tribunal. One was the extension of the jurisdiction that I've just mentioned. The other was the publication of decisions of the Motor Vehicle Disputes Tribunal. Now, both of those have been picked up in this bill. I looked at with interest actually at the annual report of the Motor Vehicle Disputes Tribunal, and I have to say that it looks like it's a fairly effective body. In the last year that they've reported to, so that's the year ending June 2010, the Motor Vehicle Disputes Tribunal had 266 applications, and that was up on the previous year. So whether that's there are more difficulties or whether greater understanding of the process, I'm unclear about that, but certainly they go on to report that 93% of all applications heard had a decision issued within 2 months of the date of filing. 95% of all applications were heard and a written decision given within 3 months of the date the application was filed. So that seems a reasonable sort of process. Now, what is interesting is in their annual report they go on to provide examples of cases that in the adjudicator's opinion require special mention, and they're quite interesting actually. So the ones that were raised in the annual report of the Auckland Tribunal talked about a car fair trader and the purchaser was a young Spanish holiday maker who went to the Auckland car fair at Ellerslie Racecourse, very close to the part of Auckland that I'm working in, the Maungakea electorate, and it's all about the car that he purchased and the issues that went on as a result of that. The second one they draw to the attention was, I thought, quite interesting as well, which was faulty transmission in a 6-year-old vehicle which had only travelled 34,000 kilometres. And as the daughter of a mechanic, that does seem to be a bit out of order that such a thing would happen. So that was the third case they drew to the attention, and the second case. The third case was around contaminated diesel or a faulty fuel injection system. That was the question that they were considering. So I think it is useful for tribunals like this to do that. I'm not just saying that to fill up time. It is useful for tribunals to actually draw to our attention these sorts of cases so that consumers can be informed and that we can look for trends and so on. Now, the annual report goes on to... Mr Chair, I'm sure people would love to hear more about this. Interestingly enough, in their annual report, the Motor Vehicle Disputes Tribunal makes some recommendations for amendments to the Act that the adjudicator thinks desirable on the experience of the Disputes Tribunal. Now, we are looking at amendments to the Motor Vehicle Sales Act in relation to the Disputes Tribunal. This is an example, I think, again, of good practice where we have a tribunal that are identifying where they find issues that are worthy of further attention. And I think that's a very good process. So they are making recommendations here that basically I would like to make for amendment to the Act concerns Section 94(1)(b) is the provision which requires the tribunal, for the purpose of protecting the public, which should be a fundamental part of consumer legislation, to direct the Chief Executive of the Department for Courts to publish a notice in the Gazette if the tribunal, in determining an application, decides against a motor vehicle trader. This section appears not to impose such requirements on the tribunal when it determines an application against a manufacturer, so as opposed to a trader, a manufacturer of a vehicle. And in the last case that I was telling you about, this was around whether the problem was with the contaminated diesel or a faulty fuel injection system. The manufacturer was found to have breached the Consumer Guarantees Act. But because of the wording, 94(1)(b), the tribunal was unable to direct the publication of the manufacturer's name in the Gazette, and that may be considered a gap which the Minister may wish to close by amending. Now, I was pleased to see, actually, that Ministry officials have obviously briefed the Minister well, and in his in a recent media comment by Mr Boscawen, he goes on to say that this very matter that was suggested about allowing the manufacturer's details to be published as well as those of a trader. So he's acknowledged the point raised by the tribunal, and I think that's fantastic. So this is based on real world. Here's a problem identified, Ministry picks up the issue. What does interest me, though, a little, Honourable Minister, and I'd really like it if you could answer this question for me, is it says, and I quote, "These issues are being considered as part of the One Law review of consumer legislation currently being undertaken by the Ministry of Consumer Affairs," Mr Boscawen said. Now, the One Law review, which I will talk about more later, everybody will be pleased to know, the One Law review, consumer law reform discussion paper, submissions on that have closed, but this is looking at the identification of updates, principle-based legislation, looking at 7 pieces of legislation. It specifically doesn't include the Motor Vehicle Sales Act. Now, I am aware that the tribunal deals with other acts, as I've just said, consumer guarantees and fair trading and the like, but I do worry a little bit because this certainly came up when we were debating my loan sharks bill, and the then Minister, the Honourable Heather Roy, said at that time that some of the concerns we were raising around extortionate interest rates and irresponsible lending would also be covered by the One Law process. And again, I think that that was a bit of a marginal call myself. I think it was convenient to be able to say that, to look like the government actually did care about this issue, an issue that is harming many in our community, and in the area I live and work in, harming many people, as evidenced recently, for those of you who saw the Campbell Live program, by a young man looking for loans in Onehunga and Panmure, who was offered all sorts of interest rates. But anyway, going back to the point, at the time the Minister said, well, that's covered by the One Law review process. I hear now that the new Minister is saying this issue around vehicle manufacturers as opposed to traders can also be covered by that. I'm a little worried about a thing, well, I'm going to call it review creep. I think there's a bit of review creep going on here in terms of the consumer law reform process, which is that any issue that is raised in terms of problems for consumer law is somehow being told to us all as being packaged up in this. Now, when people take the time to look at the document, certainly doesn't seem immediately clear to me, for example, how the issues of excessive interest rates in particular were a central point of this. They were marginal. There was a separate review of that process going on, and I certainly, in having a look at it in relation to the motor